Hi there. Thanks for joining me. For anyone who might not know, my name is Greg Nussbickel, estate planning attorney. And the purpose of today's video is to walk you through some of the basics of a will package. So, a will, a power of attorney, health surrogate, living will, those kinds of things. Particular documents, of course, might vary. You might have some and not others, and there may be different provisions within those, but they mostly follow a pretty similar path here. We're generally concerned with the distribution part of things, the inheritance, the who gets what side of things, as well as the who does what. So there will be an executor of your will, also called a personal representative. There'll be an agent for your power of attorney, a health surrogate for medical decisions, various other different hats that your chosen fiduciaries will wear. They might all be the same people. You might have a spouse that you've named first for everything, and then some backup successors. Those successors might act in order or together. So, a lot of things to customize, but a lot of it is also fairly standard. So jumping right into it, if you go with the will package versus a trust package, then the will is really going to be the centerpiece of things. A will, of course, only takes effect after you're gone, and it does have to go through the probate process in front of a judge in order to be admitted and proved and given effect. But that may be sufficient for your needs, and at some point, certain things may require that kind of level of administration. And if so, your will is going to dictate what happens when the time comes. So it's going to obviously have your name. We, of course, want to use full legal names, not nicknames or anything like that. A brief description of your family, marriage, children, that kind of thing. A couple of definitions. A couple of those are actually worth noting here because we do use those as shorthand terms in a lot of estate plans. The term issue, in this case, referring to your descendants, so children, grandchildren, people going down the family tree. And the term per Stirpes comes up a lot. That's a Latin phrase that just means if we have a predeceasing beneficiary, their share will go to their descendants instead. So if I had a child and she predeceased, but she had children of her own, those children, my grandchildren, would share in that distribution. So it just continues through the branch of the family tree. Your estate is really going to consist of anything you haven't earmarked elsewhere. So things you own in your name that didn't have a surviving co-owner with survivorship rights is going to be part of your probate estate and thus part of the will. Things that didn't have a beneficiary associated with them. So let's say you had a life insurance policy and there were no living beneficiaries on that, then that would go to your estate and have to go to your beneficiaries by virtue of the will. So you can always name beneficiaries on particular accounts if you want that to go directly. Really kind of depends on your wishes and the type of asset. And then we get into who's going to manage that whole affair. So the probate process does require an attorney, so someone's going to have to hire a lawyer, but there's a go-to person that will be acting on the decedent's behalf. The personal representative, the executor, is kind of calling the shots. Obviously, they have to follow all of the rules and all of the wishes in a will. But they're going to be marshaling the assets, managing things, ultimately distributing everything, possibly filing that final tax return, all those kinds of things. So you have to make sure that it's someone you trust, someone who's willing and able to take on that role. Those of you with minor children get to nominate who you would like to see as a guardian or a parent figure for that child if you die while they're still under the age of 18. Usually that's going to be the surviving parent if there is one, and if not, you get to put your 2 cents in about who you would prefer that to be. A lot of times that can be a parent if they're in a position to do that, like your parent. or another trusted loved one could step in and do that as well. The court would ultimately decide what's appropriate, but your wishes carry a lot of weight. We don't require a bond, which is kind of like an insurance policy that otherwise that executor might have to pay for out of estate funds. Sometimes that'll be required anyway. That depends on the judge, but try to have that waived to save some costs. And then the distribution side of it, the most important part, is broken up a little bit because there may be tangible personal property that you would prefer to go differently than the bulk of your estate. So you might be looking at jewelry or furnishings or artwork. You just like to see your tools go to your brother or your jewelry go to your niece, whatever that might be. We separate that because you can leave a separate memo describing all of that, and that memo can be changed without the witnesses and the notary and all that formality, so it's a nice convenience for you. But it only works for those personal items. It's not going to work for cash or land or stock, but still a nice mechanism if you want to use that. If you don't leave a list, that's fine. Everything is just going to go as part of your residuary here, which again, you can break up into different pieces. So there might be a dollar gift to a particular individual, a percentage of your estate to somebody else. Maybe you want to give your home to a third person. So we can write all that in here. Again, if that home is owned by someone else along with you and they have survivorship rights, then your will's not really going to kick in, right? It's kind of like a joint checking account. If you own that in two names, the survivor just owns it. No one refers to a will or anything like that. So you want to be sure, exactly how you own that asset. If you are married, there's restrictions on what you can give away, especially when it comes to the home. But those kind of things you might earmark one way or the other. And then everything else, and this could consist of millions and millions of dollars, whatever it is that you own that hasn't been distributed in some other fashion, is going to go wherever you say. And a lot of times that would go to your then living issue per Stirpes, or it might not be per Stirpes, it might be per capita. You don't want that to go down to the next generation, or it might exclude them altogether. If you do want to exclude somebody, we generally want to write that in particular, someone who would otherwise perhaps be inheriting. So if you have 4 children and you only want 3 to receive your assets, we want to specify so it doesn't look like that was missed by accident. And then the rest of it is really about the administration side of it, how things are going to be handled, what powers that this personal representative have, what if there's a minor beneficiary. So it gives you some flexibility about how best to make that distribution, and then that personal representative would call the shots in those circumstances. Of course, taxes, can't get away from those, although most people aren't going to have estate taxes, certainly not in Florida, and even at a federal level, that's kind of rare these days, but that can certainly change. Income taxes still have to be paid, though, if they haven't been yet, and so your personal representative would usually take care of that. Always a good idea to kind of clue them in as to, what you filed before, if you have an accountant, how they contact that person, where your assets are, what kind of debts you have, all those kinds of things will make their job a lot easier. And then when we sign, this needs to be done in person. We'll have the 2 witnesses. That'll make it a valid will, and then we'll have an affidavit that makes it self-proving and a lot easier to admit in court when the time comes and to have it proved. And so that's going to be the big part of it here. This is that memo where you might say, my gold watch goes to my best friend. You sign it, you date it, you're all set. You want to change that, you're free. Just rip it up, do another one. No need for the witnesses or the notary or a codicil or anything like that. And then the rest of the documents are really for your benefit during your lifetime. So durable power of attorney, this is for property and financial affairs. You're saying who the go-to person to pay your bills, to sign documents is going to be. Now this kicks in right away, so regardless of capacity, when you sign this, your first choice is already enabled to make these transactions for you, in good faith and above board and all that, but Still, they'll have a lot of access to things, so you want to make sure you trust them completely. And it will remain in effect even if you become incapacitated. So that's what makes it durable. And it can be really helpful. Obviously, when you're incapacitated, you can't do this planning, so you want to get that in ahead of time. And then there's just a very detailed laundry list of powers that the attorney in fact or agent or fiduciary can do on your behalf. Runs the gamut from everything you might imagine, assets that you own, they'll be able to step in and help out. Of course, you can revoke or amend this document or any of these documents whenever you'd like. So if something wasn't to your liking, you could remove that power. And we'll have the witnesses and the notary to take care of that. Similar to the power of attorney is the healthcare surrogate. So this is where you're saying who's going to step in a medical emergency. You might have one choice or two or three choices. Usually with health surrogates, we like to have one person at a time making these decisions so that the doctor knows who to take their cues from. The other documents, like a power of attorney, you might have co-agents working together and independently to take care of things. That's fine. When it comes to the will, one person at a time is usually best as well, just because, having an attorney represent two different clients who have two different ideas can sometimes create a conflict. But you can have joint or separate for pretty much everything. And then the living will, you're actually not making any choice on who's going to help out. You're just saying what will happen in certain circumstances. And specifically, you're saying you don't want life-prolonging activities to continue if there's no hope of recovery. So if you're incapacitated, if you're in one of these conditions that you initial, so you can do one, two, or all three of these, and there's no hope and the physicians feel like this is it, then you're saying don't extend things unnecessarily. And then the surrogate would be tasked with carrying that out for you. And you might have something like a HIPAA waiver as well. It's kind of already cooked into some of these other documents. But if there was some reason you just wanted to give that kind of access to health information and nothing else to somebody, you could use this document instead. Usually same people wearing different hats. And then finally, you're going to have burial or cremation wishes, maybe some preferences about a memorial or where you'd like your remains interred. Maybe you already have a plot or prepaid for that. We usually want to write that in. And then also who's going to step in and take care of this for you. Usually the same people you've picked for everything else, but it just makes it clear exactly what everyone can do and what you want to have happen. And so that's pretty much the usual suspects. Again, you may have different documents. There may be, more or less or different provisions for your particular needs, but it's a pretty kind of general overview. Most of the questions that I get asked was covered in that kind of a run through, but obviously anything that you have that might be more specific, just let us know and we'll go from there. Appreciate your time. Take care.